Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about delay to trial. Cases that should have gone to the Supreme Court of Canada, but didn't. Brandon McNeil was charged with an offense, had a trial, and was waiting for a decision to be rendered by the judge. Unfortunately, the decision got delayed, and continued to be delayed on the basis of the fact that the judge was ill. The Crown continually requested updates from the court about when the judge might be available, and ultimately the matter went for a new trial because the judge, as a result of their illness, was no longer available to hear the case. When the matter was set for a retrial, at that point, the accused applied for the case to be thrown out on the basis of unreasonable delay, and his application was successful. This case raises really important issues because in the context of the analysis that Jordan requires judges to do, they look for things like exceptional circumstances that couldn't be controlled by the parties, or unusual circumstances or discrete events. And often things like illness are considered to be discrete events. But this case also raises important issues about the way in which a discrete event, like a trial judge's illness, has a limit on it, in that the discrete event itself can't cause more delay than is necessary. And it would have been really interesting to see the Supreme Court of Canada's analysis into what is a discrete event and the outer limits of a discrete event, how trial judges, assessing the amount of delay that has been caused in a case, should determine the amount of delay that arises or legitimately arises from a discrete event. And what is the analysis that is supposed to be done to determine whether delay arising from a discrete event is legitimate delay or illegitimate delay because it's taking too long? Like, for example, a court not accommodating the fact that they know that the judge is on a long-term illness-related leave. These are important issues for the Supreme Court of Canada to address, and the number of applications related to delay to trial is significant. They take a lot of court time, which actually detracts from other things, so more clarity from the Supreme Court of Canada would have been appreciated, and they should have heard this case for that reason. Unfortunately, it'll take another situation like this before the Supreme Court of Canada has the opportunity to consider the outer limits of delay in the context of a situation of a discrete event or an exceptional circumstances. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brandon McNeil for putting together these videos. Please like, subscribe, and share with your friends.